am Judge Eileen Nadelson, retired, and this is another session of Tell It to the Judge. In this program we discuss, or I will discuss, some interesting, I hope, interesting cases and disputes that I handled when I was on the bench in New York City. And you will find that some of the disputes that came before me are not unique. Pretty much everyday experiences, things that you may have encountered or will encounter in your own life experiences. For instance, I'm going to start with the first case that you will see could very well happen in your own lifestyle. It started with, it's New York City, but in the boroughs, there are some houses. They're kind of close together, but they are separate houses. And in this particular case, in one of the boroughs, there were, one of the neighbors built a fence. It was like a decorative fence between the two houses. So he put up this very nice decorative kind of fence, but in order to give himself an edge, instead of putting it right on the line of his property, which would have sort of cut a little bit of his own land, he put it on the inside of his neighbor's property. So it was about, I'd say, 6 inches on the other side of his property into his neighbor's boundary line. And the fence was put up. It was a nice fence. The neighbors were very friendly. They knew each other for years. They chatted over the fence. They waved to each other in the morning when they were going to work. The driveway was 2 driveways coming up on each side of that fence with a little property on in between that. Very friendly situation. They lived together next door, door to door, for well over 2 decades, maybe 20, 25 years together. Now, in New York City, the minimum time frame to have use of a property is 10 years. Now, when I say use of the property, it's usually adverse use of the property, which technically the neighbor was using his neighbor's property for his fence. It was on the other side of the boundary line. And he did it openly, notoriously. The neighbor next door never complained about it. They were friendly about it for years, as I said, more than 20 years. And then one day, guess what? As things would happen, they weren't talking to each other anymore. Something happened, they had a falling out. Now there's no more talking over the fence. There's no more waving at each other in the morning. They don't talk to each other when they see each other. There's not a friendly atmosphere between these 2 neighbors. And one day, the neighbor, with the one with the fence on his side of the property, was tending to his rose bushes, and he noticed, these rose bushes, that fence is a little over my rose bushes, so he's on my property with his fence. And I don't want his fence on my property because, remember, they're not getting along too well together. So he told his neighbor to get that fence off his property. And his neighbor said, no, it's been there for years. I'm not moving it. It's staying. Well, okay, guess what? What happens? It's at court. He sued his neighbor for having infringement of his property. And it was, because it was over on the neighbor's property. And they're now before me at court. So this is the rule. If you take your neighbor's property and you use it openly, without permission, you don't have any permission, and nobody complains about it, then it becomes theirs. Surprise, surprise. In other words, that fence got to stay there. He didn't have to remove it because the neighbor whose property was being usurped actually had to be aware of the fact that it was on his property, and he had to tell him to move it off within that 10-year minimum period. And if he didn't, then tough luck. It becomes part of his neighbor's property now. Now, you can't do this, but this is just so you know to keep your eyes open, because if he had given him permission, if the neighbor, when they were friendly, said to the other neighbor, you know what, it's okay, you could leave it there, but I just want you to know that it's part of my property and it's not permanent, then it could never have become the other neighbor's property because he knew about it, he gave him permission to use it, but he could always take it back. But there was never any permission given. There was never any notice about it. It became the other neighbor's property. I'm sure that didn't make him too happy. Now, you can't do this with public or government property. You can't, for instance, you live next door to a preserve, let's say. Up here, you may live next door to a preserve. You can't take, you say, well, what's the difference? I'm going to build a tree. I want to widen my property a little bit. It's only preserved. They'll never use it anyway. 100 years from that time, they could say to the new neighbors or anybody who takes over the property, I want that tree pulled up, or I want that fence taken down. This belongs to us. It's a preserve. You can't do it with government property, such as, let's say, an affordable housing complex. So that technically belongs to the government. You can say, well, you know, I'll put my fence a little bit over on their park area. They don't really use it. It's where the drive is or the cars are. Nobody will notice. It doesn't matter if they notice or they don't notice. There's no, they need no warning for that. 10 years from that, or 20 years from that, or 100 years from that, that government could say, get that fence off our government property, and you have no choice. At your expense, you have to move it. So you can't do this with anything but private property. But up here, like I got to tell you, I moved up here. I love it up here in Lewisboro. I live on a lot of property, and I don't know, I mean, I have a survey when I bought the house. I know there's a survey, but I don't know whether or not my neighbor down the road, I don't have next door neighbors, but I don't know if we have a lot of acreage. So I don't know exactly where my drive ends, begins. I don't know if he's using his hedge somewhere up my drive. I don't think about it, and I don't really care. Because there's a lot of property here, so, you know, so what if he takes a couple inches of my property? It's not a big deal. But it will become my neighbor's property if I just don't do anything about it. It's going to be his property in the long run. So that if I sell this house and they do a survey again, and he has a hedge or a tree on that area of my property, it's going to be property that is not going to go to the new neighbor, the new owners. That's a done deal for them, because I never did anything about the time frame. And up here, it might be a little bit longer, because we do have a lot of property up here. So in New York, it's 10 years minimum. It might be 20 years up in this area. Different places have different regulations. I'm not sure, because I don't really know all the rules up here yet. But what I'm saying, what I'm passing on to you, is you have a heads up on being aware of your property. And if you are not taking that care, you may lose it. That's the bottom line, all right? And now I want to go to another case, another incident of not unique, it could happen to you kind of stuff, all right? And I'm passing it on to you to give you a heads up on that. This has to do with commercial property, all right? We're talking about a commercial operation. Now remember, I'm in New York City, so you have stores on the street and sidewalks. But it could be Orchard Square, you know, that little enclave in Cross River. It could be a strip mall. It could be a shopping mall. One of those type places where there's commercial operations, and there's some sidewalking and some drive-ups and things of that sort. All right. In New York, it's not really a drive-up; it's parking on the street. But in this case, the case I'm going to talk to you about, this was a store on the street. And the person tripped and slipped. He slipped on something in front of, not in front, but in the area in front of the store, all right? And got hurt. So he had medical injuries. And he went into the store. He got hurt. He went into the store. He did some due diligence. So he went into the store, and he found out who the owner was. And he was smart enough to say, well, is that the name of the company? Because John Smith could be the owner, but it might be operating under ABC Company and not John Smith. So he was smart enough to figure out that. He got all the information from the store. And then he got medically attended, and there were expenses. So he told the store, he says, hey, I slipped in front of your store. I need you to pay me back for some of these injuries. I was hurt. And the store owner said, nope, not my responsibility. I'm not concerned. I don't want to be bothered, whatever. You know what the story could be. So he sued the store. And guess what? It's my case. They're now before me. This person, the reason why I'm making a deal of this, because this person sued the store. That has some substance to it, as you'll see him later in this discussion. He sued the store. The store owner said, not my responsibility. Well, in New York City, as it is everywhere, in New York City there are regulations and requirements on who is responsible up to a certain footage. So in New York, the store owner is responsible up to a certain area just before the curb. That's the store owner's responsibility. Anything within the frame of the store property, they have to maintain, and they're responsible for it if they don't maintain it. In this case, the store owner, what he did is he went outside and he poured some oily, sticky stuff off the curb in front of his store. But that area where he poured the sticky stuff was the property of the city. So it ended, in other words, at that curb area, it now became the responsibility of the city. That's how it works in New York. So the store owner had this part, now we're in the city area. But the person sued the store. Well, guess what? The case was dismissed because he's not responsible for that part of the curb. Even though you're saying, well, wait a minute, he poured this sticky stuff off the curb. Yeah, now the city could sue the store. The city could say, hey, you shouldn't have done that, and it's costing us money because this person is injured. We're going to sue you. You got to pay us back. But the person who got injured on that section cannot sue the store, not his responsibility, all right? So, now, okay, so you say, well, Judge, it's only been a year or so, but you're at court, so let him sue the city. Good thinking, too late. In New York, and this applies up here too, I'm sure, in New York, you must, if it's a government-owned part of the property, like a city owns it, you need to give them notice. Because the city's not there all the time, so in order for them to know that they are responsible, if something happens when you slip on government property, you need to give the city notice. And that requires a form. It's called a notice of claim. This man never did that, didn't know to do that, all right? And that's only 90 days, folks. That's all you get in New York City. You must tell the city within 90 days if they are responsible for injuries on their property. And he didn't do that. So it was too late. That's the end of the case with the city. Now, I guess you could say maybe a good lawyer can make an argument about it. We're not going into that details. I'm giving you a heads up on what you need to do. If it's a government-owned property, what I'm saying is you need to first find out who owns the property. Like, for instance, up here, let's say you went to a strip mall and you fell. There are rules here for that. There's rules for maintaining in front of the operation, and then probably the part where you drive up, the parking spaces which come up to that area of that store. That's probably another responsibility. That could be town. It might be owned by the town, which means it's not the store owner's responsibility. Or it might be a developer. It might be the person who bought that property and developed the whole thing. That's okay because they are not government, and you could sue them within that 3-year period of time, which is what you get to sue a private person. So if you didn't sue the store, and if you sued the store and it wasn't their problem, you could still sue the developer because the time frame was still running. But if it's the town, let's say the town owned it, then you only have a certain period of time to let the town know that they are going to be responsible for this. Up here, I'm guessing, I don't know, it could be 180 days up here because there's a lot of property, and the city, they probably give you more time to put in a claim in the more rural areas. Don't hold me to that. But it was 90 days in New York, and if it's past the 90 days, and if it's past the time frame up here, you're going to be up the creek without a paddle, is what we say. So I caution you on, if you are injured, you actually find out who is responsible for that particular part of the property. Of course, if you're in the store and you're tripping or falling or slipping inside the store, then that's a done deal. You know the store is going to be responsible. However, here's another caveat. The store has to know that there's something wrong there. So if you are walking down the aisle and somebody just dropped something slippery or slimy right in front of you, then we're assuming that you're going to know it's there and you're going to walk around it. You're not going to walk over it or slip into it. So you might be held accountable for just being aware of it. But if it's sitting on the floor and you're distracted, you're carrying bundles or whatever, and you step into something that you didn't see was dropped, then the store would be responsible, believe it or not. And if you notice now, we have, I don't know if you know, in the supermarkets, they have these robots. In my supermarket, one of the ones I go to, they have a robot that goes up and down the aisles. That is specifically to avoid liability, folks. It's not like a little attractive gadget that they just want you to smile at. That robot is designed to go up and down the aisles to see if there's anything in the way, any barriers that people could trip over, anything slippery on the floors. Then it flashes. It makes a noise and it flashes, and that notifies the manager that something's happening or has happened in that aisle. That's notice to the store. And this way they can never say, if they have a robot, you're covered, because that robot is giving them notice all the time. If you slip in a store and they have a robot, you're in good, well, not good shape. We hope you don't get hurt. But that's the reason for that robot, is to avoid liability on the part of the store. And that's how you need to know who owns and who is responsible for what your injuries, for what injuries have been caused to you. Got that? All right, so now let me go into another case where I thought was an interesting case. It's off the subject matter of property. This had to do with a name change. Now, just to preface that, you can use whatever name you like in this country. Doesn't matter. You don't have to come to court to change your name. You can decide that you don't like your name. I don't want to be Janice anymore. I'm going to be Joanne. Just change it. You know, instead of Janice Jones, you're now Joanne Jones. You change your banking. You start calling yourself on your bank, on your checkbook, Joanne. You open up credit cards with Joanne, not Janice. You take your new car, you buy a car, and it's under Joanne. You can use whatever name you like in this country without having to go to court or change it. You don't have to come before a judge. However, you should notify Social Security because it could be a hassle later on. If you are now operating as Joanne Jones, and you can also tell your employer that you are Joanne Jones, you're signing everything as Joanne Jones and not Janice, you're going to have a Social Security at the date of birth. We all have Social Security under Janice. So it's going to be a little tricky when you retire. Janice could be lost to you because you've been operating as Joanne all those years. So I would suggest you just let them know. Now, that could become a problem. Social Security sometimes wants you to make it official, but it doesn't necessarily have to be so. They could just make a note that Janice Jones is also operating as Joanne Jones, and then they bring the two together for your Social Security funds when you retire. That could happen. You also will probably have to tell DMV, because if you own a car and then you change your name, it's under your Janice, and now you're operating as Joanne, you get stopped for a ticket or whatever, there's going to be a little bit of a hassle about who are you and who owns this thing, and it just pays to just tell the agency, I'm now operating under this name. Doesn't need any court certification, right? You just have to tell them. Now, this person that we're going to talk about wanted it to be official. He wanted it to be official. And the name was, I'm going to make this up, it's not who the name is, of course I'm not going to tell you the name is, but he wanted to be known as Count von Dracula Smith. He was John Smith. We're giving him the name John. He was John Smith, but he always wanted to be known as Count von Dracula. So he came to court, and he wanted it changed on everything. He wanted his birth certificate changed. He wanted all his documents changed. He wanted his Social Security changed. He wanted to be known as Count. All right, that was going to be his only name ever. So when you come to court and you want it to be official, now you have to make it official. There are some requirements. We ask you the reason why you're changing your name, not because we care. I mean, we won't stop you from that. You could say, I just don't like my name anymore. I want to be known as Count von Dracula. That's enough for us. We give you whatever reason you like. But we want to know if there's any children that you have to support. You're not trying to hide out from child support. You're not trying to hide out from an an ex-spouse that you may owe matrimonial money to. You're not in debt and you're trying to hide out from credit dealers or bank accounts. You're not hiding out from law enforcement, like you're not some criminal on the run, and you want to change your name because you don't want to be found out by the police. We need to know that the reason why you're changing your name is not for some illegal and untoward rationale. So that's why we ask you, what's the reason for this? And the only reason could be, if you're on the up and up, I don't owe any matrimonial, I've never been married, my children are all grown up, and of course we ask you to show that. We want to know there's no children that need to be supported. So you give us documentation of grown children, their birth certificates. You show that everything's been paid up in a divorce case. We know that you're not a criminal, so we can check that. You have to show it. Give us credit cards that everything's okay with that, like a credit rating, a credit report kind of thing. Bank accounts, to show that everything's in the clear. You're not declaring bankruptcy. Those things, we need to see those things to know that you're not running from somebody and you're trying to defraud someone out of paying funds. And once you clear that hurdle, and if you could clear that hurdle, then the last step is publication. You need to publicize, now that you've changing your name officially, this is officially, not just using it, to your like. This is going to be on your birth certificate and everything else. If you do that, it needs to be publicized, which means it has to be in a newspaper. That's what we require. And people usually choose the cheapest paper they can get, like you choose a local paper up here. They use a very cheap paper in the city. Otherwise, it's very expensive to publicize in the New York Times, for instance. It could be thousands of dollars. So they choose the cheaper ones, and it has to be done for about a month or so. You can't just do it once. It has to run for a while to give people the chance to see that you are now, or were, John Smith, never to be known again as John Smith, from here on out to be known as Count von Dracula Smith. And that's publicized. Then you come back to the court again. These are all the requirements for changing it officially. We see the ads. You have to bring us back the ads and the dates when they were being shown. We stamp. Now you click, click. You are now Count von Dracula Smith. Congratulations. Now you will have to, we don't do that for you, you will have the papers from the court saying you're now Count von Dracula. You're going to have to tell the health department, for the birth certificate. You're going to have to send them a copy, so they change it on their records. You're going to have to send it to Social Security, so they change it on their records. You are never to be known again as John Smith. It's a new name starting from scratch. You probably have to send it to the DMV, because now you changed the name on that, for motor vehicles. Those are the agencies that you just send the copy of not the original, the copy of the court order, and you're in business forever as Count von Dracula. So I gave you 3 incidents, and you could see this could happen to you kind of thing, or you may find yourself in that position at one time or another. You need to be alert as to what is required. That's what my objective is for you. And also, I want to encourage you, if you'd like, you can send me one of your own disputes. I'm open for hearing something from you. I'm going to give you a number, and I also started a new email. I have an email for Judge Nadelson. Please don't use that. I use that for my colleagues and my legal business, so don't use my regular email. This is specifically an email for the TV show. I opened it up specifically for that. So first, get a paper and pencil, get it handy. I'm going to give you my number. So you can either call me. If you want to be anonymous, you could send me a letter without a return address, and don't even sign it. And I won't even know who you are. Oh, wait, you can't do that. I take it back. I don't give out my address. So the only way to contact me is through number, which is, I will know who you are through a number. I'm not going to use it. You'll have to trust me as a judge. I'm not going to use your name. I will tweak your case so that it doesn't sound like you, so that somebody doesn't say, oh, that sounds like Alice. Alice had that problem. I will change it. I will sort of embellish it and redesign it a little bit, so it's not going to be the way you tell me. And I'll put it on the air, but it won't sound like you. I will protect your name and identity, but I will have to know who you are if you're going to send me some information. So this is my number, okay? 917-327-6487. That's also for text if you want to text. This is my strictly television email. So it's Judge N. It's got 2 E's and 2 N's. Judge ENN@gmail. And that is strictly for this television program. I will know, of course, who you are because you're going to be sending me an email. Don't worry about that. I'm going to wipe it out after I speak to you. I will respond to you and we could talk about it, about your case, but I'm never going to use or contact or use it for anything else besides using your particular incident. And with that, we're going to close up this session. Until next time, thank you for stopping by and viewing us, and see you next.
You're watching Lewisboro Community Television, Channel 20.